Hi, I'm Anna Denton-Jones of Refreshing Law, and in today's session I'm going to talk about the new employment bill and one specific area of it, that of removing the 2-year qualifying period to claim unfair dismissal. I'm going to make a second video on the initial period of employment, what we tend to call probation, and how that might interact with that. But I'm going to confine myself in this video to just talking about the removal of the 2-year limit. So to summarise how we get to where this new bill is going to be, historically there are a set of circumstances in which employees can bring unfair dismissal claims from day one. But they're a narrow set of specific circumstances. So it's things like where they've whistleblown, where they've raised a health and safety concern, where the law deems there's a good reason why they should be able to bring an unfair dismissal complaint from day one. For everybody else, there's been a time period that they've had to wait to bring a claim. And that has moved over time. During my career, the shortest it's ever been was 1 year. And David Cameron's government put it back up to 2 years. It has historically been 6 months back in the 1960s. The new Labour government have trailed for a long time before they got in that they would get rid of that. And so potentially an employee from day one will be able to bring an unfair dismissal claim. Alongside that, traditionally the right to request from the employer written reasons as to why they've been dismissed has been level pegged with that 2-year period. So that will also come down now, so that straight away, if somebody has started employment with you, they have the written, they will have the right to written reasons for their dismissal. In terms of when this is likely to happen, we've been told unlikely to happen before autumn 2026. So in reality, that means that people that you go on to recruit now, before Christmas into 2025, when the law changes in, say, October 2026, abolishing the 2-year rule, those people will already be working with you and so will already have protection on the day that legal change comes in. So culturally, quite a big difference in the sense that managers are no longer going to be able to play with that 2-year rule and think to themselves, well, it's okay, I can just see how this person pans out and I've got a long time to make a decision. And if they decide to bring somebody's employment to an end before 2 years, mentally be thinking, I can do this really swiftly, even to the sort of apocryphal manager walking into an office and saying to people, clear your desk, you're gone. Those days are over. The employer is going to have a potentially fair reason for dismissing somebody and follow a fair process, whether it's in the beginning of somebody's employment or if it's in many years' time when they've been with you for a long time. There is going to be an exception to that, which is called the initial period of employment, and I'm going to make a separate video about that specific. But it probably means we need to be a bit tighter on our recruitment. We need to be more accurate in our record keeping around things like performance, so that we've got clear job descriptions, so that we've told the person what it is that they are expected to do, so that when we then want to start saying they're not doing it, that we have got the evidence and the ability to then start having those performance conversations. If I was going to give us marks out of 10 on performance management, that's probably an area that we're all really weak on. So certainly something to start in preparation for 2026, really thinking about training of managers and prepping what your performance management system is going to look like, so that you're hitting the ground running when you get to 2026. As I said, I'll make a separate video about the initial period of employment. My email, if you need it, is adenton@refreshinglawltd.co.uk.